We start the legal issues module with an introductory recording. Now, recreation law, or the legal aspects of parks and recreation, is a whole course in itself. I know the master's program at George Mason has an entire course dedicated to the many legal aspects of the field. But what we're trying to do is cover some of the key information in 1 week as part of a broader understanding of the issues that impact recreation and parks agencies. So what I'm trying to achieve through this recording is provide some foundational material and at a sort of surface level skim the full breadth of law and legal liability. All of the different areas of law I discuss in this recording are supported by additional materials and specific recreation and parks cases on the Canvas site, so make sure to check those out. To set some context, it's important to tip our hats to the legal system as it operates and functions in the US. Now, Shivers and Halper suggest the legal system in the US exists as a sort of paradox whereby law is dynamic, constantly in flux and developing in the context of changing conditions and situations, while at the same time laws maintain stability, accountability, expectability and protection. Sharp, Moorman and Clawson suggest the US legal system operates under the belief that we should allow citizens as much access to the formal legal adjudication of disputes as possible, which is why you sometimes hear of or have first-hand experience of legal cases that just seem nonsensical. In other words, the legal system in the US very much operates on an open door philosophy. However, legal issues and the law is a good place to start following our first module on strategic planning, because a superior operation means a safer, better run organisation and thus one that attracts more clients or participants. Really, compliance with the law is the very first step organisations must achieve if they are to become legitimate and successful entities. But why should recreation practitioners even care about the law? Isn't that what certain agencies have keep a retainer on lawyers for? But I really like this quote from Shivers and Halper, who say, without the benefit of formal legal education, what can the recreationist do to reduce the potential for litigation? And the only practical response, at best partial and subject to real limitations, is for the practitioner to become conversant insofar as is possible with the legal problems that have ensnared other members of his or her profession. Such knowledge will enable the recreationist to try to avoid repeating the errors committed by others through deficiency of understanding or technical facets of the law. So that is what we are trying to do and achieve through this module, and the assignments is to develop a working understanding of the facets of law. Much of what we'll discuss over the course of this module is based on the idea of liability, which is that condition for which an individual or corporation is answerable and out of which arises a responsibility to perform in specific ways, which the obligation is enforceable by court action, hence a legal responsibility. So to simplify that slightly, legal liability is essentially the state of being responsible for something by law. Now, I mentioned before that there's lots of different ways in which the law intersects with recreation and parks agencies. Here, this hierarchy chart shows the three main branches of legal liability. So you've got criminal liability, civil liability, and constitutional torts. Criminal liability is where a person is liable or responsible for a crime when he or she has acted with criminal intent. With the time limitations we have on this module within this broader course, it doesn't make sense to take a deep dive into criminal liability. Instead, in this introductory recording, I want to spend a little bit of time progressing through civil liability and constitutional torts. Constitutional torts are legal actions to pursue damages for violations of constitutional rights. Individuals bring constitutional tort actions against the full range of government officials, from the cop on the beat to the state governor. So municipal, public, parks and recreation agencies definitely fall under that range. An example are the rights to privacy, which is an act by a defendant that constitutes a serious and unreasonable invasion of privacy. Also, within constitutional torts are matters of gender and race discrimination, so Title VII and Title IX, disability, so ADA regulations and compliance. I've included a couple of different constitutional torts cases specific to the recreation and parks field on the Canvas site, which I've taken from the NRPA website. So take a look at those. They're under the supporting material. Contract law, on the other hand, falls under civil liability and is a significant area of law in its own right. For example, many employment-related lawsuits and claims are associated with breaches of the terms and conditions included within employment contracts. Specifically, a contract is a promise or set of promises for breach of which the law gives a remedy or the performance of which the law in some way recognizes a duty. Contract law is essentially concerned with clarifying and enforcing the will of the parties in determining agreements. Importantly, when courts become involved in contract disputes, they are concerned mostly with trying to give effect to the parties' intent. In other words, courts aren't trying to rewrite contracts to make them better for the parties involved. Again, I've included two different contract law cases from NRPA on Canvas under the supporting materials section. Intellectual laws refer to the rights associated with patents, copyrights, trademarks, trade secrets, and trade dress. A single product could receive intellectual property protection for its design, label, packaging, and slogan. As such, there is specific legal doctrine that relates to patents, copyrights, trademarks, etc. I found it difficult to find specific intellectual law cases relating to recreation and parks, but what I did find was an interesting article about Little League, the organization. They seem hell-bent on filing claims against anyone who dare use the trade name Little League to market products to consumers. So we move on to torts, okay? And a tort is a civil wrong other than a breach of contract, usually referring to the causing of damage or harm to property, a person's reputation, or a person's commercial interest. And you can see that tort has four further subcategories, okay? So there's strict liability, intentional torts, nuisance, and negligence. Strict liability is called liability without fault because one does not have to prove fault for liability. Strict liability for defective product is based on a public policy rationale that responsibility for unreasonably dangerous products ought to be placed where it will most effectively reduce the risks to consumers. And to determine if a product is unreasonably dangerous, several jurisdictions use a risk utility balancing test. So if on balance the social utility of the product outweighs the risk to the consumer, then it will not be considered unreasonably dangerous. One of the areas of strict liability that is of interest to recreation and parks practitioners is product liability, which is liability for harm caused by a consumer product. There are two types of product defects that may cause injury. So you have design defects which exist when the very design of the product is flawed so as to render that product unsafe, and then there's also manufacturing defect. Okay, so the result of an error in the manufacturing and production process that results in a flaw in one or more of the manufactured items, even though the design itself is a safe one. Malfunction in recreation and sports equipment can cause injury within any negligent action on the part of an instructor or participant. When this does happen, the injured party may sue under product liability law. Just to further help establish the difference between a design defect and a manufacturing defect, I have a couple of non-recreational examples on this slide. So, as an example of a design defect, there's a toddler toy designed with a small detachable choking hazard, like Disney's Forky toy on the right hand side of the screen, which was recalled because the plastic eyes can pose a possible choking hazard if pulled off the toy. An example of a manufacturing defect is a batch of medicine that contains a toxic substance, like when the FDA recalled medicines in 2018 because batches of it potentially contained a chemical used to induce cancer in lab rats. Intentional torts are when an individual or entity intentionally behaves in a way that causes another person harm. Intentional torts, as they relate to persons, include assault, battery, false arrest, defamation, and intentional infliction of emotional distress. Now, acts of assault or battery can also be tried under criminal liability, but under intentional torts, we're usually talking about a wrong committed by one person against another, causing damage to which the plaintiff is seeking monetary damages from the defendant. Defamation is an intentional tort which protects one's reputation. Defamation claims are intended to protect a person from false statements that are damaging to his or her reputation or that will diminish the esteem, respect, goodwill, or confidence in which a person is held, or that cause adverse, derogatory, or unpleasant feelings or opinions against the person. Of course, defamatory statements can be both written, libel, and spoken slander. A nuisance is an unreasonable, unwarranted, and/or unlawful use of property which causes inconvenience or damage to others, either to individuals and/or to the general public. Nuisances can include noxious smells, noise, burning, misdirection of water onto other property, illegal gambling, unauthorized collections of rusting cars, indecent signs and pictures on businesses, etc. Some people think exercising in public parks is a nuisance. Nevertheless, if a nuisance interferes with another person's quiet or peaceful or pleasant use of his or her property, it may be the basis for a lawsuit for damages and/or an injunction ordering the person or entity causing the nuisance to stop or limit the activity. Although acts of nuisance are commonplace in open spaces, I did actually struggle to find a specific case example to post on Canvas, but what I was able to find was the Oregon state law that covers action by state or any person to abate public nuisance. Finally, negligence describes a situation in which a person acts in a careless or negligent manner which results in someone else getting hurt or property being damaged. In the context of recreation and parks, premises liability relates to the duties owed to invitees by facility owners and operators, whereas participant liability refers to the duties owed to participants by coaches and instructors. Negligence is discussed in much greater detail in the next recording. So that brings to an end this introductory recording on the full breadth of legal issues, and in the next recording we'll dig a little deeper into two prominent legal areas within recreation and parks management, that is participant and premises liability. Bye for now.